A pleasant day to you, ma'am. I'm Jela Corsiga, BS Ashim 3A. Today I'm going to discuss the topic about the Chapter 12, laws related to tourism, investments, and finance, and legal aspects in tourism and hospitality. So these are the learning objectives of the topic. First, explain the laws governing tourism investments. Second, discuss the business models applicable to tourism projects. Third, enumerate the various taxes application to tourism-related establishments. Lastly, is discuss the limitation of foreigners in tourism investments. So these are the contents. First, laws governing tourism investments, business models applicable, taxes, and lastly is foreign investments. So introduction. It has been the policy of the state to recognize the indispensable role of the private sector like the tourism industry and provide incentives for its needed investments. This chapter deals with laws related to promotion, monitoring, and regulation of tourism investments and finance in the country. Basically, this will tackle the participation of foreign investors as well as incentives given to Filipinos in case they will invest in the tourism industry. Special laws are even created to address needs of certain sectors like the informal sector, Filipino balikbayans, retirees, and senior citizens. So here are the laws governing tourism investments. Investments in transportation, business, and public utilities. So the Article 12, which is the National Economy and Patrimony, Section 11, no franchise certificate or any other form of authorization for the operation of a public utility shall be granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines or at least 60% of whose capital is owned by the such citizens, nor shall such franchise certificate or authorization be exclusive in character or for a longer period than 50 years. So franchises or rights can only be granted with the provision that they can be amended, altered, or repealed by Congress if necessary for the common good. The state promotes public equity, participation in public utilities. Foreign investors' involvement in public utility enterprises is restricted to their capital share, and all executive and managing officers must be Philippine citizens. In short, common carriers like airlines and land or water transportation services, which are public services, can only be operated by Philippine citizens or organizations with at least 60% Philippine-owned capital. This means foreign participation is capped at 40%. Furthermore, all executive and managing officers of these businesses must be Philippine citizens. So investments in travel agencies and tour operators. The following may apply for accreditation as tour operator. First is a resident Filipino citizen, a partnership organized under the laws of the Philippines, at least 60% of its capital being owned by Filipino citizens, and corporations organized under the laws of the Philippines, at least 60% of the subscribed common or voting shares of stocks of which is owned by Filipino citizens, and the composition of its board of directors being at least 60% Filipinos. So the law limits foreign participation to 40% for the accreditation and operation of travel agencies and tour operators by the Department of Tourism. So tourism activities are classified as preferred activities under the Investment Priorities Plan. To be registered under the plan, an applicable must meet the following criteria. First is if an individual, they must be a Philippine citizen. If a partnership or association, it must be organized under Philippine laws with at least 60% Philippine ownership and control. So if a corporation or cooperative, it must be organized under Philippine laws with at least 60% Philippine ownership of capital stocks, and at least 60% of the board of directors must be Philippine citizens. So the applicant must propose to engage in a preferred project listed in the current investment priorities plan within a reasonable time. So the applicant must have the capability to operate efficiently and contribute to the national development of the preferred area and the overall national economy. So the investment in hotels, resorts, and other accommodation establishments. So this law, by reason of the enactment of Memorandum Order Number 211 approving the 2006 Investment Priorities Plan, April 4, 2006, tourism has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. Tourism covers the development of tourism economic zones, tourist estates, eco-agri-tourism facilities, and the establishment of tourist accommodation facilities. So to register tourist accommodation facilities under the investment priority plans, the applicant must meet the following requirements. First, if an individual, they must be a Philippine citizen. If a partnership or association, it must be organized under Philippine laws with at least 60% Philippine ownership and control. If a corporation or cooperative, it must be organized under Philippine laws with at least 60% Philippine ownership of capital stocks, and at least 60% of the board of directors must be Philippine citizens. So applicant must propose to engage a preferred project listed in the current investment priorities plans within a reasonable time. So the applicant must have the capability to operate efficiently and contribute to the national development of the preferred area and the overall national economy. So the business models applicable to tourism projects. So joint venture. In a joint venture, which is similar to partnership, two or more persons bind themselves to contribute money, property, or industry with the intention of dividing the profits among themselves, which is the People versus Caballero, in which is 204-59 to CR August 26, 1981, which is a joint venture is formed when parties agree to work together towards a common goal with equal control over the project. It may or may not have separate legal identity. If it qualifies as a partnership, it is taxed as a corporation. But if not, it has no legal personality. One example of a joint venture is when two construction companies come together to collaborate on a specific infrastructure project. They pool their resources, expertise, and manpower to complete the project efficiently and effectively. Both companies share the risks, costs, and profits associated with the venture. Once the project is completed, the joint venture is dissolved, and the companies may go their separate ways or choose to collaborate on future projects. So taxes. Here are the various taxes application to tourism-related establishments. So value-added taxes. So a 12% value-added tax, which is VAT, is imposed on individuals engaged in trade or business, including the sale, barter, lease of goods or properties, provision of services, and importation of goods. So VAT is based on the gross selling price or value of the goods, properties, or imported goods. So let's say there is a business that sells goods to customers. The business is registered for value-added tax, and the VAT rate is 12%. So when the business sells goods to customers, it adds a 12% VAT on top of the selling price. For example, if the selling price of a product is $100, so the VAT amount would be $12. So the customer would pay a total of $112, which is $100 for the product plus $12 for VAT. Now, percentage taxes. If a person's annual gross receipts are below 550,000 pesos, they are exempt from paying value-added tax, which is VAT. Instead, they need to pay a percentage tax, which is equivalent to 3% of their quarterly sales. So, for example, let's say a small business earns 100,000 pesos in sales for a quarter. Since their gross receipts are below the 550,000 threshold, they don't need to pay VAT. Instead, they would calculate their percentage tax by multiplying their sales. So 100,000 pesos by 3% is 0.03. So their quarterly percentage tax payment would be 3,000 pesos. This applies to domestic carriers, keepers of garages, and international air carriers and shipping carriers doing business in the Philippines as well. They also need to pay a percentage tax of 3% based on their quarterly gross receipts. So excise tax is a tax imposed on specific goods that are produced or imported for consumption in the Philippines. So it is separate from the value-added tax, which is VAT. Examples of goods subject to excise tax include alcohol products, automobiles, and luxury items like jewelry and precious metals, perfumes, and yachts. So the excise tax is due as soon as the goods are removed from the place of production or manufacture. It is an additional tax on top of the VAT that may also be applicable to these goods. So for instance, if a company produces and sells alcoholic beverages, they would need to pay both the excise tax on the alcohol products and the VAT on the sales of these products. So customs and import duties. Customs duties are taxes imposed on goods that are imported or exported. When a carrying vessels or aircraft enters the Philippines with the intention to unload goods, the importation process begins. So the goods are released or withdrawn from the customs house after payment of customs duties or with a legal permit. For example, if someone imports a vehicle, whether it is a brand new or used, purchased or donated, it is subject to customs duties. The customs duty rate is 40% of the vehicle's book value. In addition, a 10% value-added tax is applied. So there is also an ad valorem tax, which ranges from 15% to 100% depending on the vehicle's piston displacement. So the book value of the vehicle sourced from recognized motor vehicle reference books like the Red Book, Blue Book, or World Book is used as a tax base. So the purchase price or acquisition cost is not considered. Any spare parts that are sent with the vehicle are taxed separately. The travel taxes. According to the law, when Filipinos or other nationals travel outside of the Philippines, they need to pay a travel tax before they leave the country. This tax helps generate revenue for the government and is required by law. For example, if a Filipino citizen is planning to travel abroad, they would need to pay the travel tax before their departure. The amount of the tax may vary depending on the destination and other factors. Duty-free Philippines. So duty-free Philippines is a system in the Philippines that allows people to buy goods without paying import duties or taxes. So it was created to help generate foreign exchange and the revenue for the government. The Department of Tourism, through the Philippine Tourism Authority, is responsible for establishing and managing this system. For instance, when travelers visit duty-free Philippines, they can purchase items such as cosmetics, electronics, and luxury goods at lower prices because they are exempt from import duties and taxes. Foreign Investments Act of 1991. The Foreign Investments Act of 1991 defines a Philippine national as a citizen of the Philippines, a domestic partnerships or association fully owned by Filipino citizens, a corporation organized under Philippine laws with at least 60% Filipino ownership, or corporation organized abroad but registered to do business in the Philippines with 100% Filipino ownership. So it also includes trustees of funds for pension or employee benefits, where at least 60% of the fund benefits Filipino nationals. Small and medium-sized domestic market enterprises with paid in equity capital below $200,000 are reserved for Filipino nationals. However, if they involve advanced technology or employ at least 50 direct employees, non-Filipino nationals are allowed with a minimum paid in capital of $100,000. The term doing business includes activities such as soliciting orders, opening offices, appointing representatives or distributors in the Philippines, participating in the management of domestic businesses, and other acts that imply continuous commercial dealings. However, certain activities like mere investment as a shareholder, having a nominee director, or appointing a representative or distributor transacting business in their own name and account are not considered as doing business. Limitation of foreign ownership. The limitation of foreign ownership refers to the restrictions on the amount of ownership that foreign individuals or companies can have in certain industries or sectors in a country. So these limitations are set by the government to protect national interests, security, defense, public health, morals, and the interests of small and medium-scale enterprises. So there are two lists that outline the specific limitation on foreign ownership. List A, foreign ownership is limited by mandate of the Constitution and specific laws. So So this list includes industries or sectors where foreign ownership is limited by the constitution or specific laws. So these limitations are in place to protect certain industries that are considered vital to national interest or cultural heritage. For example, the Constitution may state that land ownership in a country can only be held by citizens of that country, so limiting foreign ownership of real estate properties. So list B, foreign ownership is limited for reasons of security, defense, risk to health and morals, and protection of small and medium-scale enterprises. So this list includes industries or sectors where foreign ownership is limited due to reasons such as national security, defense, risk to health and morals, or to protect small and medium-scale enterprises. Example, the government may restrict foreign ownership in industries related to defense technology to safeguard national security. So these limitations on foreign ownership aim to strike a balance between attracting foreign investments and protecting the country's interests. By setting these restrictions, the government ensures that certain sectors remain under the control of domestic entities and that national interests are safeguarded. So that's all for Chapter 12, and I am Jela Corsiga, BS Asham 3A. Thanks for listening!